let's continue with our program with the media and the court of last resort, case studies from the Inter-American Court of Human Rights. Our moderator is our dear director of the Latin American and Caribbean Center here at Florida International University, Frank Mora.
Thank you. Thank you, Alejandro, and thank you all for being here again. So this is supposed to be a workshop, and the way we want to sort of lay out the way we want to proceed is we're going to give each of our panelists here 5 to 7 minutes, 5 to 7 minutes each to sort of lay the groundwork, and then really try to get the audience very involved and ask questions, not just of the panelists, but really I'm going to ask questions of the audience, right? And sort of have that kind of back and forth rather than a sort of question and answer that we're having. And I know more people will be arriving soon, but I'd like you to start thinking about how you can engage us, and we'll be thinking about how to engage you in some of the questions and issues that will be raised in this panel. Let me briefly introduce our two guests here, and then we can start it off. First, to my left here, Asdrúbal Aguiar is a man of many professions. He's a lawyer, an author, an academic, a journalist, an expert on a number of issues related to economic integration. He is from Venezuela. We've been having a lot of discussion this morning about Venezuela. But more importantly, for the purpose of this panel, he served as judge of the Inter-American Court of Human Rights. And he, I'm sure, will be able to tell us a little bit about his experience and about that institution, which is the subject of our discussion. He has been an ambassador for Venezuela, a governor of Caracas, a minister of the Secretariat of the Presidency, etc. His academic, legal, political positions and accomplishments are too long to list here today. And I just want to thank you, Asdrúbal, for your participation.
Gracias.
And your next to him is my good colleague from Florida International University, Ediberto Román, who is a professor and a member of the founding faculty of the College of Law at FIU. He is also a man of many interests within the law. He's an expert on contracts, torts, corporations, comparative law, antitrust, and so on. His recent work, and the one that I find most interesting and related to today's topic, is his issues and discussion about immigration. He's got a book recently on immigration that I hope he can talk to a little bit about. He's been working hands-on with undocumented parents, immigrants, on a number of issues of interest to their education, to their legal status, and of course he's been working also on international issues. So Ediberto, thank you again for your participation. Just to set the context up, I think it's important to remind ourselves that we are not only living at a time where we see sort of retrogression in the freedom of expression, attacks on the media, but that the inter-American system itself, from the OAS, from the Organization of American States on down, is also seems to be under assault or part of efforts to weaken that institution, that structure that has been around, one can say, for more than 100 years now. And so whether you're talking about the Organization of American States, the Inter-American Commission on Human Rights, the Inter-American Court, there's different special rapporteurs to include the Special Rapporteur of Freedom of Expression. All these are under assault. There are efforts to undermine and to weaken these hemisphere-wide institutions by certain states in the region. And one of those institutions, which is the subject of today's panel, is the Inter-American Court, that I'm just happy to see that as well has joined us here today to talk about his experience and his views about this process of attack or weakening of this particular institution. So with that, let me turn it over to him and we can begin this workshop.
Thank you, my dear friend. I'll try to summarize as much as possible the volume of ideas that I have in my head, because I have a brainstorm in my head based on on what I heard throughout the panel, and having paid attention carefully to what the panelists said. Let me start with a practical consideration, because we are talking about the inter-American system. And excuse me that I'm talking about specifically about the Venezuelan case. According to the Inter-American Democratic Charter, democracy is respect and guarantee of human rights. Venezuela withdrew from the Inter-American system. It denounced the Inter-American Convention on Human Rights. We went up from 4,000 murders a year to 23,000 after, in August 1959, the government of President Chavez signed a pact of an agreement of tolerance with the FARC, which is documented. The democracy is at Aguiar. In the past few days, in this last month, we have 30 people dead, 32 to be exact, 459 people wounded, 59 who were tortured, and 1,800 Venezuelans who are detained, and 800 subjected to interim court measures. So as a result of a state violence that was organized gradually in the course of 15 years in the military and social spheres. In the social sphere, obviously, because President Chavez made the decision of changing the definition of the president according to the institution, creating an active military position, which is the people in arms transformed into militias, added to the military structure, and in a parallel fashion, then became the Bolivarian circle, that then became the revolutionary circle, and then become the popular collectives, which are the sectors that used to perform criminal activities in many Venezuelan neighborhoods, and in order to control them in some way, giving them a function and giving them regular police activities. So the human rights in Venezuela has been violated to this date as the result of the state policy. The democracy is the separation of powers, and these are objective data, not subjective. The president of the National Assembly, Captain Diosdado Cabello, a month and a half was in the state of Zulia, and by an executive order removed the military structure of that state without being the commander-in-chief of the National Armed Forces. Ms. Corina Biachado is going back to Venezuela, and without an official formula, she's divested of the parliamentary protection because supposedly she committed a crime against the fatherland without a judicial order. The lack of freedom of the press, and as a result of the change in the law, the independent press has no paper in order to circulate massively. So an hegemony, a monopoly of the state for media from one single TV station. Now we have 560 radio stations for the propaganda activities of the government. and democracy is the rule of law and access according to the rule of law. So the President Chavez on December 8th in 2012 told the country that his successor was Nicolas Maduro Moro. According to our constitution, in order to start a constitutional term, you need to have presidential oath as a question of form and not of substance. Nicolas Maduro could not assume as a vice president because Chavez died without giving oath. And then the president of the parliament assumed the president. But he was the vice president in the 1999 Venezuelan constitution. Expressly says that the vice president of the republic cannot be a presidential candidate. The Supreme Court in the constitutional hearing decided to oversee those two standards and to approve Nicolás Maduro according to the Inter-American Charter is to have access according to the rule of law. And today the constitutional division upon petition by the president in a trial that lasted 24 hours removed from their position two popularly elected mayors and sentenced them to 4 months of jail as if it was a criminal court. Again, democracy is freedom of the press and of expression, and N24 was expelled from the country, and some CNN correspondents were also expelled. And in Venezuela, we are informed about what's happening exclusively through the underground networks that are disturbed every once in a while by the government itself because they control the servers in the country. However, and this is the reason for this preliminary explanation, the Secretary General of the OAS was asked whether he thought that in Venezuela there was the minimum the democracy was affected in the least in Venezuela, and he said that there is nothing wrong with democracy in Venezuela. It's working perfectly well. The Inter-American Commission at present, it has indeed a sort of a paralysis. Who practiced before it, because I have several cases from Latin Americans who have asked for my assistance when I introduce a complaint based on a violation, the time that it takes between filing the complaint and the decision by the commission, just by sending that complaint to that government for it to answer, nowadays takes 5 years. 5 years. And only just to move the complaint. So what's happening in the court of which I was a part? The Inter-American Court, if you see its case law, you'll find an extraordinary and marvelous surprise. More than 600 decisions. That is doctrinary paragraphs of the whole case law issued by the Inter-American Court since 1987. They developed fully the 12 standards on democracy cited by the Inter-American Charter. We should say that for the court, it has full legal power. But the Secretary General of the OAS, who is the head of the organization, says that there's a paper that is there that won't stand the predicate of non-intervention in the internal issues of a state. At the Inter-American Court, we don't talk about the Santo Santorio of Jerusalem. The judges are human beings who are living their own realities, and the standard related with the freedom of expression have become coherent based on the consultative opinion of 1985 until the year 2008. Strangely, there was a stop. One wonders what's going on. And it turns out that the American Convention is a law that imposes obligations on the state, not to private citizens, but rather it measures how the state is acting at a national level in its relationship with its citizens and supervising the relationship between one citizen and another. But the court supervises the government behavior. Then there was the Kimmel case against Argentina, and a very broad manner in a court that was totally divided, found encountered this Justice Sergio Garcia Ramirez defended the legacy of freedom of expression, the right to seek and give information, the right to no censure on the freedom of expression, the principle of ulterior obligations. Of course, if I abuse my freedom of expression, I can be subjected to consequences, but it has to be of a restrictive nature. They have to be provided in a formal, actual law. They have to be compatible with the convention, and they must be the injurious consequences that are necessary from the point of view that is from the social and proportional point of view. But why? Because of a reasoning that used by the court. But freedom of expression is the spine of the democracy. The Kimmel case in 2008, there was a division. Garcia Ramirez defending this legacy, and President Garcia Román saying no, the right to honor and intimacy and privacy is as important as the expression, the free expression of the thought. And so when there is a conflict between them, there has to be a balance, a syncretism of laboratory to see how you can defend one while defending also the other. Until the previous date, the thesis was very simple. If there is abuse of freedom, in order to subject an issue of public interest to debate, there is indeed some kind of major protection for freedom of expression and less protection for the right to privacy and honor. So starting on that day, that remained in a sort of a critical balance. And even though in the Kimmel case, who filed a suit because he sued for a slander and he won at the Inter-American Court, the principle, which was decriminalization with respect to freedom of expression, was simply over. It went back to the legitimacy of the use of criminal law to censure freedom of expression. But a detail was added, and with it, I will conclude. A detail that strikes us powerfully. 122, the Restrepo case. And you will tell me, you will ask me, what do you think about this? In the paragraph 122, in the judgment of Pérez Restrepo versus Colombia in the year 2012. Here it is. This court is of the opinion that there is a duty on the part of the journalist to prove reasonably, even though necessarily exhaustively, the facts on which he's basing his opinions. That is to say, that it is valid to demand equity, confrontation with the sources, search of information, the journalist has the duty to have a critical distance from its sources in most compared with relevant data. The European Court has even pointed out there is not an unlimited freedom for journalists, even in issues of public interest. They are covered by the protection of freedom of expression, the court says, but they must perform their duties while abiding by the principles of responsibility, acting in good faith, providing precise information. They must give reliable information, reflecting faithfully the opinion of those involved, and refraining from sensationalism. That was unadmissible until 2008. There was the Sullivan Doctrine that was practically definitive. What's worse, and I'll finish here with the last case, which is the memory case against also Argentina. The Inter-American Court not only went back on this consideration on freedom of expression as the spine, and that's why its tuition on the issues from the constitutional point of view, but rather in the memory case, two journalists were sentenced because they opened a debate about the misadministration of public property of a cemetery by an Italian private corporation. The corporation tried to have this criminal case against these two journalists, so they were sentenced for defamation and slander. And Inter-American Court not only distanced itself from the fact, but but it said that the court was not only in the position to go over those issues that which can be handled more properly by the national judge, and that the court only has to do with the strictly formal issues of the application of the Inter-American Charter.
It's enough if it is foreseen in a law, if it complies with a conventional end to protect the honor and the reputation. And if the judge has thought that takes him to consider that a sanction that he is applying is proportional and necessary, the Inter-American Court does not have to review even the bottom of the matter, but just check if the judge did it at that exercise at the national level. So in conclusion, what is happening? That the process of relaxing of the standards that we have known in a democratic way are being felt also in the Inter-American Court, with something particular that is good to note, with votes that are totally divided. But why? Because they reflect the double vision that I see it in the conflict of OAS in ASUR. In the OAS, always it was imperative due to the doctrine of the court, what is known as the principle of omni libertati. In each conflict, you have to favor always the individual and his freedom. But the democratic vision that starts to assume by UNASUR and CELAC with its new democratic statutes makes of democracy essentially a system that should be interpreted not pre-human liberty but pro-government or governor. And that is exactly the situation under which unavoidably they are suffering. The freedom of expression is suffering, really. The jurisprudence of the court in relation to what they call the power, always demoniac of the media. And that is what is justified, the law in Argentina of the audiovisual law, the responsibility of the law in radio and television, in Ecuador, the organic law of communications, and all those are set, especially the one in the Venezuela, to make hegemonies of the state. And this is a topic of public interest, and that is why the intervention of the state is more as active than in the past. Thank you.
Dr. Mora, to be here to give this presentation. My first with the center after being at the law school for quite a few years. I wanted to take a moment to look at the title of the panel in part. When we talk about these issues, we look at the panel and it basically is entitled "The Media and the Court of Last Resort," a case study, basically. Case studies we're examining. As you see from the honorable and wise words of the previous panelists, we looked at Venezuela. In terms of my comments, I'm going to look at particularly the issue currently before the Inter-American Commission as it relates to the denaturalization case in the Dominican Republic. But before I do that, I want to resituate or provide a slightly different narrative to the title of the panel. And I want to call it "The Media as the Court of Last Resort," particularly in the context of the issue with respect to, I think in many respects, Venezuela as well as the Haiti issue. But I want to take a moment in terms of speaker's privilege, to the extent I have any, to raise another issue that I think that is related, and it's often viewed from a domestic perspective, but rarely, if ever, addressed in English media. And given the abundance of media leaders here, members of the press, both in terms of Spanish as well as English, I want to talk about kind of the dearth of discussion and debate on international matters, particularly when dealing with the Latin America or the Caribbean. I give credit and kudos to major Spanish-speaking networks on these issues, but often their partnership or sister stations are devoid of discussion on any of these issues. And I come to you in this vein, reminded by a comment made by my colleague yesterday when I gave a presentation. He alluded to the fact that I was a conscience of the law school. I think what he meant, I'm the troublemaker of the law school. So we're keeping that in that vein, I want to raise a couple of issues, particularly when dealing with immigration reform. Currently, Florida in particular is kind of the hotbed and the epicenter of debates related to immigration and immigration reform, with issues such as the ability or inability of DACA recipients, deferred action recipients, young people who came to this country with their parents largely coming here to seek work, and for most of their lives saw themselves as Americans. Only later in life, when they either applied to universities or sought their driver's license, that many of them, I would venture to say most of them, find out their quasi unusual status, but for our purposes, undocumented status. This is a huge issue. Their estimates are anywhere from 150 to over 200,000 young people in the state of Florida alone, and up to 2 million in the country are addressing these issues. And in terms of our immigration laws as well as our criminal laws, these are individuals without fault. They have no mens rea. They have no criminal intent. These are individuals that by and large are stars. I can say that with good conscience, because I feel very proud that the College of Law has helped more DACA applicants than any institution in the country. And I was able to see firsthand, despite what the media, in many respects, not so much the media, news media, but popular culture, I should say, depicts young people in terms of immigrants. But yet there's almost no discussion. There's almost no discussion in the popular press, particularly English-speaking press, on these issues. And it's a shame. It's disheartening when among the biggest civil rights issues of our day are being debated throughout our country, and English-speaking media just doesn't address it. Well, let me give you another case study. So I say that as a provocateur, so to speak, and a troublemaker, hopefully to incite some of you to think about ways in which we can continue these discussions, as well as our grassroots efforts that are done throughout FIU and with conferences like this, but also to get to the frankly, get to the politicians and have the influence you can have in media. And I do believe that the change in Florida in recent times, particularly in political circles, when just 3 years ago, Florida was considering adopting a copycat Arizona law, to right now in the Senate thinking about in-state tuition for Dreamers, it's a dramatic change. And that change came from grassroots efforts of young people and others that have been involved in court decisions that have been successful. I'd like to see the media be more involved in that regard. Well, let me look at, for a moment, switch gears a little slightly more germane to our discussion for a moment, to perhaps provoke further discussion, which involves another matter I work on in human rights related work, and that's the denaturalization case in the Dominican Republic, as some of you know. And feel free in terms of my questions, if you have any, my comments, if you have any questions, be it in English or Spanish, I'd be happy to respond. But in terms of the denaturalization case in the Dominican Republic, we're talking about a decision that came out by the High Court of the Dominican Republic, the Constitutional Court, a fairly new court, consistent with the constitutional amendments that occurred in 2010, to basically provide a court of last resort, what that we know as lawyers we call a court that has judicial review. The long and the short of it, that court had the opportunity to review and examine issues that had been debated in the legal system in the Dominican Republic for over 10 years. And in a decision in the Inter-American Court of Human Rights in 2005 that condemned the Dominican Republic for denying the right to education to two young ladies that wanted to go to school, two children that wanted to go to school, but because they couldn't get their birth certificates, they couldn't attend public education. And rightly so, the Inter-American Commission and Court of Human Rights condemned the Dominican Republic. So the Dominican Republic, in response to a lot of political machinations, changed their constitution. And more recently, and I'll truncate my comments, hopefully some of you have questions concerning it. In the fall of 2013, it interpreted the new constitution of the Dominican Republic to do away with one of the basic forms of citizenship. And when we think of citizenship, the classic forms of citizenship in Western societies, and recognized in the Dominican Republic pursuant to their 1929 constitution, that said if you are born in the Dominican Republic or of parents that are Dominican, you are a Dominican national. It's unequivocal. It's unequivocal. The language of the pertinent constitution says that. Well, this court interpreted that constitution, a phrase that says, unless you are in transit, okay? This court basically held, this is the High Court of the Dominican Republic, held that essentially 4 to 5 generations of Dominicans, people that see themselves as Dominican, that don't speak Creole for the most part, that view the Dominican Republic as their country, basically the court said that these people are in transit for 100 years. For 100 years, essentially, 80 some odd years. And that argument was raised in 2005. And the Inter-American Court said that it's absurd and is a basic principle of all juridical systems, be it Western or Eastern. You don't interpret language in a constitution, in a statute, or a decision in a way that it's absurd. It's a basic premise of construction, and that's exactly what occurred. This resulted in obviously some protests within the Dominican Republic, very little in Haiti, some outside sources such as CARICOM and other institutions putting pressure. But basically we're talking about a stateless people, and we think of our leaders, the Enlightenment, from the Enlightenment thinkers to philosophers of the day. There is nothing worse than being stateless, because that positions you in a place where you have no rights and protections. And that's where these people are. Yet, it's almost untouched by English-speaking media. It's fascinating. It's only when people in Miami, particularly some FIU folks, did the Associated Press cover it, and very little discussion. And as my colleague here talked about the court and the years it takes to address these matters, I'm really concerned that this absurd decision is going to result in a political solution. And because the narrative right now, this is an immigration issue, And I tell you that it is not. It is a citizenship issue. It's a constitutional framework issue. It is not an immigration issue. That same philosophy was tried, and not to be a partisan, but Mitt Romney ran on a self-deportation model to make life so miserable for the others, the immigrants, that they would leave. Well, Dominican Republic has taken that model on steroids and looks to leave 500,000 people as stateless, and it's not being touched upon nearly to the point I think it should. The result will be that eventually the president of Dominican Republic will announce, I believe, within a year or so, that they're going to do away with just soulless citizenship, birthright citizenship. They're going to try to find a way to address the 80 years of absurdity, the retroactivity of the decision, to put these people in a pathway. And again, human rights are going to be lost, and we're not going to touch upon it nearly as much as we should. Thanks.
Thank you very much. So let's go into the comments and discussion. I mean, if I was to phrase, right, the whole day's discussion is sort of where's the outrage? Why is there such indifference on the part of the media, governments, and others about these issues that in some ways we might think are so obvious in terms of its injustice, right? But there is more silence than voices out there from the different sectors as to this situation that we've been talking about today, and particularly this panel. And I'd like to hear from the audience, in addition to questions, sort of their reactions to this silence, this indifference, this effort to weaken inter-American institutions, weaken the courts, and there's not a response, really, to call this out on the part of the media, as Ediberto says, or from government. So let me turn that over to you. And Alejandro has a mic who will walk around. If you raise your hand, we'll come to you. Not sufficiently provocative, I see. Right there.
Buenas tardes. Esta pregunta para el doctor Aguiar. En cuanto a la...
This question is for Aguilar. In the Court of Human Rights, there's the case of Leopoldo Lopez, that was inhabilitated politically by the government of Venezuela. He went to court and he won the case. How will the Inter-American Court do to comply with this decision? Do they have some type of mechanism so that that decision has some type of effect? Is it just emblematic or representative? It is supposed that within a society where there is respect for the rules of democracy, of the functioning of the rights of the state of the law, and when you understand that the institutional apparatus is the state of the international one, is there to respect and guarantee everybody's rights and all the rights for everybody, the decision has to be complied with in good faith. When there is uncompliance, that ordinarily the court does, is that necessarily each year they report to the general OAS organization that somehow they, in such a way, exercise the pressure on the state that is kind of in a rebel situation and complies. Until a very recent past, when a country in Latin America was pointed out because they incurred in massive violations and systematic ones of human rights, and eventually they would go to the European Union searching for a loan, for example. The same bank was saying, no, look, we cannot give you that loan because you are a state that we have not respected the human rights. It's not that the states, members of the OAS, have been very diligent in the compliance, but all at the end have complied with a certain delay, but they have complied. The exceptional situation is stated in the case of Venezuela, because look, the Argentine constitution in the matters of human rights says exactly the same thing. that the Constitution in Venezuela says. What has the Supreme Court of the Argentine said? That jurisprudence and the decisions of the Inter-American Court are directly and immediately linked in the internal order, and even the national judges have to make control of those conventions when they dictate their respective sentences internally. So what did they decide with the same norm? The room of the General Justice, what the Secretary of the OAS says, since you cannot interfere with internal order, and there's the principle of independence and autonomy of the state, they decided not to comply with the decisions of the Inter-American Human Rights Court under the hypothesis that they can be violating the rights. And in consequence, if they would be complied previously, they would have to be reviewed by the a higher court of that state, the Supreme Court of the state. So imagine an international society where each state or contracting party interprets the international order according to their own national perspective.
I don't want to scandalize you, but that vision assumed by Venezuela is the one that predominated in the international legal community and made possible the First and Second World Wars. And when the Second World War took place, that's when the states were told, look, you have sovereignty and independence, but there is a limit of a public order. And what's the limit? You cannot wage war to solve conflicts. That's illegal. You have the obligation to solve conflicts peacefully, and you have to respect the universal human rights. And that's why the OAS, and I must say so without any type of prudence, until Mr. Insulza came to office, there was a doctrine that was undisputable. No state can put in question the principle, can use the principle of sovereignty in order to cover up violations of human rights. That has changed on the fact the judgment of Julio Lopez was not obeyed by the government, Venezuela government, neither the other one, and the decision by the government, by their own Supreme Court, was to simply separate themselves from the system. So one question, this implies that Venezuela can with impunity violate human rights? No. Peru, I remember the case. Mr. Fujimori was the president. At that time, I was in court. There were threats of this nature, and the court kept issuing its judgments. And Peru would not abide by until Mr. Fujimori left, and Valentin Paniagua, during the transition, proceeded to comply with all the decisions made by the court. So now we'll have to wait. Thank you, Dr. Aguiar. Just to remind you, Venezuela is it's not the only session. Venezuela has not abided by many of the decisions of the court, especially by the derogation of the amnesty law. Then I have to ask you, what coercive action does the OEA has to enforce mandatory decisions? Look, regrettably, the OAS is the reflection of the governments that are sitting there. And that was a question that I asked Dr. Insulza 6 or 7 years ago at a meeting that we had here in the United States. What had happened between 2001 and the current time? In 2001, where it was accepted that the democratic charter not one also legally mandatory, but rather the democratic charter, even though it was a resolution, was interpreted as an authentic interpretation of the American Convention and the OAS Charter. So at that time, all the American presidents were concerned by a bad example, Fujimori, who was elected popularly, and it degenerated in a true autocrat. Regrettably, that disease had made metastases, and nowadays the OES is a reflection of what we have. What to do? Look, if we're talking about legal instruments, I'll tell you the following. The Inter-American Charter, which is the authentic interpretation of the OES statutes in the event that there is a situation where there are serious alterations of the Constitution and democratic order, not a coup d'etat, just serious, grave alterations that give up the guarantee of human rights, because they don't respect the separation of power. The Secretary General is under obligation to present a report to the permanent OAS Council, and that council has to adopt a first measure to send a mission to that country where there is that situation, so that the relationship with the OAS club is normalized. And if that is not achieved, then a meeting of prime minister, of foreign ministers, is decided to expel that member state. So what happened? Strangely, the current OAS, with respect to Venezuelan issue, they prefer to do a blackout. And additionally, when it issued its decision before the blackout, that at least divided the OAS, it decided that there was nothing happening in Venezuela. Strangely, they went to UNASUR, and the Secretary General of UNASUR was the petroleum minister and minister of the economy for Chavez, and they had a mission. And the question is, why did the UNASUR send a mission and not the OAS, when indeed the members are relatively the same? Because the interpretation from below is democracy as a system of government. The perverse interpretation that is not accepted is that democracy is a human right of the peoples that governments have to guarantee. So there is a dual cosmovision, and the conflict we have today is precisely there are those who defend the sovereignty of the state as if we were at the beginning of modern times, and other peoples, on the other hand, they think that the time of globalization is a time to deepen the primacy of freedom and rights above the organs of control and guarantee. Emilio. I am in the pessimist field, so to say, because I have the impression that it's not just an issue that governments do not obey the decision by the Inter-American Commission on Human Rights. In the times of the military dictatorship in Latin America, they did not abide. They would say these are organizations infiltrated by international communism, and people laugh. They were not abided by. And nowadays, the governments say that we don't obey because those organizations are controlled by the world great media, the great multinationals, and the world says that is they are winning the ideological war. They are founding their eye. Oh, because it's the oligarchs, the millionaires, they're not on the side of the poor. 1,000 arguments. So it's going to be a lot more difficult. Maybe if some governments change, we might be able to find the change. But rather than changing the governments, we have to change the mind of many people. Like the case of Colombia this time, Juan Manuel Santos has simply doesn't feel like abiding by the decision by the Inter-American Commission on Human Rights that orders to respect the elected mayor of a city and president of right wing. He says that will not obey it. And why can he do it? Because the world public opinion is losing its reflexes, not just governments that are not abiding by the world public opinion is not understanding the importance of defending the democratic freedoms based on the whole issue of arguments that anyway people accept. It's not a question, it's an opinion, but I'd like to hear opinions about my opinions. Okay, so I share your thesis, but I'm not a pessimist. I am a fervent militant of hope. I think that what is happening now in these circumstances, and I will exaggerate, is that the West, at least, the West, at the end of the 80s, early 90s, it suffered a great breakdown from the point of view of its world vision. The age of globalization, it broke down the government, the state that became jails of citizens. So as societies became more and more educated, they had larger lungs. They were more critical. In fact, their demands were beyond the capacity of the state to respond. The people decided to do the following. They abandoned their identity within the state. This is in line with your argument. And they accepted what Unamuno said, the campaigns of the belfries. People prefer, for example, an ethnic or religious definition rather than have a passport, belong to gender or to be of a green color, to those or become an urban tribe. And in view of that reality, in which citizens overnight discovered that the state cannot solve his existential problems, in that situation, these witches turned up. What does it mean? I always say an example is like a man whose wife dies, he has bankruptcy, his son is murdered, and before committing suicide, there comes a third party. Why don't you read the tarot or the tarot, or why doesn't somebody tells you your fate? So these witches appeared that gave a sort of social control to these pulverized societies. This is a general situation that we are living through, but it's temporary. What had been the great deficit of Democrats? That at the time that this breakdown happened in the 80s, the Marxists did not go to Mars. They remained on Earth. They revised their world vision and they rebuilt themselves, not conceptually, but strategically and tactically. Is to go back to the old model by using democracy to empty it, in order to empty it, and to go towards this model based on the same railway of capitalism. And Democrats, that we believe that with the breakdown of the Berlin Wall we had won, and the catechism of the French Revolution and the American Revolution had become a dogma, we did not realize that all the categories of democracy had also given ground. And with this, I'm not saying that democracy is over, but rather that its standards are subjected to revision. The problem is that there is no political player that is revising those standards, because we do have a tragedy. Those standards need libraries and need reflection. and we have a generation of Twitter leaders that only write 120 characters. Very good for the development of public policy, but it's totally insufficient in order to recreate a world vision. And let me do a very brief exercise because in 2009 I found this paper. I read it at some times, and I would ask this question in front of some students. Democracy predicates the international character of human rights. And I say to myself, how can I reconcile that universality with the relativism of modern age regarding multiculturalism? Democracy is the rule of law, the general and abstract law, all of us equal before the law, and political parties as integrators of common interest. So I cannot reconcile these premises with those popular ideas, the right to be different and the right to be treated as such. You find a native, and very rightfully, I want to see the world totally from the native perspective, and an environmentalist exactly the same. For example, for elections, that has been the most universal of all. It turns out that the development of electoral technology has allowed to take over the electoral system in Venezuela, Ecuador, through digital autocracies. Voters, we no longer know whether elections are any good or not, because we have to bet on a magical mathematical formula that will tell us whether the popular will was expressed well or badly. So there is a reminder. The socialism of the 21st century took up its old of the old structure, took up the digital world, and we keep doing the same catechism. Of course, governments are a bit out of sync, because they have the problem with the press, at times with TV, but rather with the written press, which is the Jurassic Park. And why do they do it? Because they have realized that the press, this situation, it affects politics. The press is the memory of society. While it is pulverized, the press orders information in a context of global disinformation. The press articulates what the society says while it recreates its own constitutional forms. And the press generates the word, which is what the socialism of the 21st century likes. You wonder, Dr. Shafi, what do you think about Asdrúbal? He says he's a fascist, and you ask me, based on the categories I found, I learned in university about fascism, I would say about Mr. Chavez, he's a fascist. So the same word signifying one thing for a sector of the opinion market and another thing for the other market. So why does the market of public opinion doesn't move? Because the word was disturbed itself. And that's one of the tasks that we precisely are behind, the need for new dictionaries that allow us to regenerate the specificity of words, so the markets of public opinion can take up again their democratic strength. This task is still pending, but the time will come. Por favor.